it compels the majority to commit its reasoning to the permanent record, which happened. Read the majority options in AD and Goel alongside Justice Khanna's dissent, and one finds a complete account of constitutional choices before the court. Constitutional choices before the court are always open. What you choose, your choices make you what you are today. So you will also face a lot of opportunity where options are there, choices are there. What you choose becomes the history. And therefore, it is important, and the cost and all those things. So I will not take much time, but these critical reflection, again, say a couple of three things I will say. First, judicial independence is not an achievement that can be secured once and then filed away. This is very important. And second, the culture we now take almost for granted. The judges disagreeing openly and recording the disagreement in writing is a 50 years achievement. Now today you are saying dissent has become very sacrosanct also, acceptable. People now are acceptable to dissent. There is no hard wording on that. So it happened, like on same-sex marriage, when Justice Rajendra bench met, there was a dissent. In so many cases. But point is, it gives perhaps the most remarkable way for the growth of jurisprudence. And that is something very, very important. And I take this opportunity that all those who are making presentation, all those who are coming as a panelist, they are actually contributing to the cause of a very important movement. These are the festivals that the law universities should celebrate. These are the occasions which we must remember. These are the moments we must actually remember, recall as inspiration. So Justice Khanna was never made Chief Justice of India. 50 years later, his name is not remembered for the office that was withheld from him. It is remembered for the principle that he defended. When the defense carried a real and immediate cost. That, I believe, is the true measure of legacy this conference has actually examined. Thank you and Jai Hind.
Thank you so much, sir, for enlightening the gathering. Now, I would request Dr. Shruti to take over the stage for panel discussion.
Now the floor is open for interaction. So our dear students, if you have any question that you would like to ask, so you may ask now. Please raise your hand if you have any question. Respected Honorable Vice-Chancellor, sir, Professor Dr. G.S. Bajpai, Respected Honorable Vice-Chancellor, Professor Dr. Devendra Singh, Worthy Registrar, Professor Dr. Ashutosh Mishra. Okay. And our distinguished panelists. Everyone, please be seated. Our distinguished panelists, Professor Dr. Pradeep Singh, Dr. S.K. Chaturvedi, Dr. Deepak Sharma, respected members of faculty and dear students. A very warm good afternoon. It is my singular honor to welcome you all to this panel discussion, or if I may say, a constitutional dialogue. India's emergency was one such defining moment. It was not simply a period of political upheaval or turbulence, it was a profound constitutional crisis. Civil liberties stood curtailed. Constitutional guarantees appeared vulnerable, and delicate balance between individual freedom and state power came under extraordinary strain. Yet, when the Constitution faced one of its gravest tests, one judicial voice refused to surrender to the demands of the moment. That voice was Justice Hansraj Khanna. Whenever Justice H.R. Khanna's name is invoked, the conversation almost instinctively turns towards ADM Jabalpur case, popularly known as habeas corpus, that you might have been listening since morning again and again. Yet perhaps the more compelling question is not merely what Justice Khanna decided. It's actually how and why such solitary dissent continued to command greater constitutional authority than the opinion of majority nearly 5 decades later. Now the answer lies not only in the courage, as he himself has attested in his autobiography, Neither Roses Nor Thorns, Justice Khanna nevertheless refused to compromise with what he regarded as the Constitution's most fundamental promise. And in doing so, he transformed a judicial opinion into constitutional legacy. Now, in this way and in many other ways, it explains the significance of today's panel discussion. As addressed by Professor Dr. G.S. Bajpai, today is not just a day, it's an occasion which calls for the reflection, which calls for the celebration, as well as to address the questions that continue to confront even today's constitutional democracy. Now, to deliberate upon this thought, we are fortunate to have with us an eminent panel comprising of distinguished scholars of constitutional law and public policy. The diverse perspective will undoubtedly enrich our understanding of Justice Khanna's legacy and its continuing relevance to contemporary constitutional discourse. Now, before we begin our deliberation, it is my privilege to introduce our distinguished panelists to all of you. Professor Dr. Pradeep Singh is Professor of Law, Dean of School of Law, and Head of Department of Law at Central University of Haryana. A founding faculty member of the Department of Law, he has played a pivotal role in its academic and institutional development. With over 15 years of teaching and administrative experience, his areas of specialization include constitutional law, jurisprudence, and alternative dispute resolution. Professor Singh has held several key academic and administrative positions, authored numerous scholarly publications, and have been actively associated with the legal aid, institutional governance, and constitutional scholarship. Then we have Dr. Sudhir Kumar Chaturvedi, Associate Professor of Law at HMB Garhwal University. Dr. Chaturvedi holds his LLB, LLM, and PhD from Banaras Hindu University and brings over more than 18 years of teaching and 10 years of research experience. His areas of expertise include administrative law, judicial process, human rights, cyber law, and IPR. He is the author of acclaimed books, Judicial Process and Delegated Legislation in India, and has authored more than 55 research papers and chapters, and has been a resource person at numerous national academic programs. Last but not the least, we have Dr. Deepak Sharma, who is serving as Assistant Professor and Head of Department of Law at Dr. Rajendra Prasad National Law University, Prayagraj. He has earned his PhD from the Faculty of Law, University of Delhi. Before joining Prayagraj, he mentored students of integrated programs in law and management at IIM Rohtak, an institute of national importance, and taught at the Faculty of Law, Jamia Millia Islamia, as well as Amity University, Noida, as well as CPG College of Higher Studies and School of Law, New New Delhi. He has presented papers at several national and international conferences and published in reputed law journals. Now, before we move into the structured discussion, I would like to request our esteemed chair of the panel discussion, followed by our distinguished panelists, to offer their opening reflection on today's theme. So, may I request you to address the gathering? Okay, sir. Now, I would like to request Professor Dr. Pradeep Singh to give his opening remark on today's theme. So, it's all right, you can address from there as well.
Very good afternoon to one and all, Honorable Chair, esteemed colleagues over here, and equally important dear students. Let me start with the saying that it's very difficult, sir, to comment on something, particularly personal session, and that's true after hearing a very renowned panelist in form of Professor Bajpai in this very particular session, and as already one has already been said by Professor Rajendra Singh. So I'm just like a sandwich-like situation that we are in the house and house seems to be fatigued and post-lunch session, so I need to be aware of the fact. So without taking much of your time, and as a justice written by Michael Sandler, and he was pinpointing that right thing to do. Justice is all about the right thing to do at right point of time. Again, there is a book called Why the Constitution Matter that was penned down by Mark Tushnet, and also same was penned down by Justice Vice-Chancellor. It was a kind of compilation of his own speeches. Name is the same. Another work I would want to start with is the suffering are required to be taken seriously, Professor Upendra Bakshi. So given this particular background note, and given the kind of context we are having, Justice Khanna legacy, just want to pinpoint there are two terminology. First one is constitution. Constitution is there, as you must have been taught, your students are here, you must have been taught that it was something that in order to avoid a very like situation, anarchy-like situation, might is right-like situation, we need to have something, some sort of ideology for which by making use of the same, we can counter that anarchy-like situation. And perhaps it was amalgamation, collaboration of the people of society. They come together and they said, okay, we will draft some sort of rules, regulation for us, and in the time to come that ended up into a social contract, and ultimately it ended up into constitution. So constitution, what does constitution provide? That okay, we need to avoid that anarchy-like situation, we will provide rules, regulation and rules for governance of the people, and that rules are to be applied by the ruler. With the passage of time, does it the only thing we are in need of? No. With the passage of time, they adopted democratic pattern. With the passage of time, this democratic practice is converted into majoritarian rule. My mentor used to be very frank on it. Professor Mulchan Sharma sir, he used to say that we are in democracy, and democracy is a constant tension. And you are not supposed to have democracy where there is no confrontation. So democracy is required to be realized only through confrontation and conflict. But if that democracy is only converted into a majoritarian rule, it will lead you nowhere. It may convert it into a kind of racist state, wherein those who are in power, those who are in majority, they will make rule, regulation, and they will rule others. No as such mechanism, no as such limitation on their power. So gradually, as it has already been penned down by Justice A.K. Sikri, that it was a phase, now that constitution got converted into another phase, and that phase was that we, society, was in need to have a kind of check on those winners. Have been empowered by making use of all that rules, regulations, settled principle, maybe any constitution. Not to have that check and balances. So gradually that spontaneous growth we could witness, and that democracy, that constitution start wedding with rule of law, that start wedding with the principle of justice, that start wedding with the principle of limited government, that constitutionalism. It is the constitutionalism which matters a lot, not only the constitution. And in constitutionalism, again, I started with the premise that right thing to do at right point of time. It is not only Justice Khanna. Justice Khanna was there in minority, but we need to remember, journey start from pre-independence, 1902. Justice Mahmood, हमें पता ही नहीं. Justice Mahmood was there during colonial period. He was a cushiony judge in the Allahabad High Court, and in that particular capacity, he wrote so many dissenting opinions. And ultimately, what outcome? Same as Justice Khanna. He was shot. The Chief Justice of that particular jurisdiction, he made a complaint against that particular person, that this person is raising and creating obstacle all the time, and it make a kind of nuisance. Government asked, which government? British government asked, served a notice to the person. And he responded with 68 pages and clarify his stand that this is what the democracy is all about.